Hello everyone. Welcome to the video lecture of Intermediate Paper number 5 Business Law and Ethics for CMA Inter. Previously, we discussed on the chapter Negotiable Instrument Act 1881. Today, we'll be doing a marathon video on the important topics from an examination point of view as usual. So, let us get into it. As you are aware, from an examination point of view, a case-based scenario where you will be given a scenario, identifying the same, you will be asked to identify the concept and explain in detail. So it is important you will read the examples given in the chapter. More of a direct question is least expected. In the video, we'll be going through concepts. Understanding the concept, a case-based scenario question can come. So what is the first important topic? That is the essential features of a negotiable instrument. So you're aware, it should be in writing, it should be signed by the maker and drawer. There must be a promise. The promise or order must be unconditional. It must call for payment in money and money only. It should call for payment of a certain amount. The property in instrument may be passed in two ways, by mere delivery or by endorsement. The consideration is also presumed to have been passed. So another important topic, promissory note. More of a comparison or a differentiation can be expected, like difference between promissory note and bill of exchange. This table will give you a fair idea. Always suggested you avoid section quoting. So, promissory note is a two-party concept where there will be a maker and a payee. Whereas in the case of a bill of exchange, there is a drawer, acceptor, and a payee. Promissory note is a promise to pay, whereas bill of exchange is an order to pay. In case of a promissory note, no condition shall be in a promissory note, whereas in the case of a bill of exchange, a bill may be accepted unconditionally. Sorry, a bill can be accepted conditionally. In case of a promissory note, the liability of a maker of a promissory note is primary and absolute, whereas in case of a bill of exchange, the liability of the drawer is secondary and conditional. Also, you know what is a check. The difference between a promissory note and check can be gone through. In promissory note, there are two party, maker and payee. Check, there is a drawer, drawee and payee. In case of a promissory note, there should contain a promise, whereas in case of a check, they shall be payable immediately on demand. Promissory note is not crossed, whereas in case of a check, it is crossed. Now protection is available in case of promissory note, whereas in case of a check, there is a statutory protection. A promissory note cannot be self-drawn, whereas a check can be self-drawn. There is no criminal liability in case of promissory note. There is a criminal liability in case of a check. Stamp is necessary in case of promissory note. Stamp is not necessary in case of check. As far as the Limitation Act is concerned, the time period is 3 years for promissory note, whereas in case of a check, it's 6 months. So what is the difference between bill of exchange and check? You can go through. Bill of exchange are not crossed, checks are crossed. There are three parties in both of the cases. Generally, 3 days of grace are given for the payment in case of bill of exchange. Immediate payment is required in case of check. Anybody, including banker, must be a drawee, whereas drawee can be always a drawee is always a banker. Drawee is always a banker. Bill of exchange, it must be accepted before the acceptor can be made liable upon. Whereas in case of check, it should be immediately paid. A bill of exchange is not paid or not honored, a notice of dishonor should be sent to the drawee in charge. Where a check is dishonored, notice of dishonor is strictly necessary. The banker can return the check with a memo referred to the drawee, which is sufficient notice. Statutory protection is not available in case of bill of exchange, whereas in case of a check, it is available. Civil liability is a case of dishonor in case of bill of exchange, whereas in case of check, there's a criminal liability. Examples are very important. You can go through that. Another important thing is crossing of check. There are different modes of crossing. You're aware, general, special, special more than that, crossing check. So you should be very familiar of what are the different types of check, which we have discussed in the previous video. Concept of endorsement, you should be very well aware. An example you can go through wherein a question can come. All this area can be covered with a simple comparison. Here you are going through all negotiation. There is assignment coming. So this one table will cover you all this topic which we have earlier. This many pages has covered. What is the difference between negotiation and instrument? Negotiation, considering is presumed until contrary is proved, whereas in case of an assignment, consideration must be proved. Negotiation, it transferee is a holder in due course. He takes the instrument free from any defect. But in case of an assignee, the title is always subject to the defenses and equities between the original debtor and assigner. Negotiation, notice of transfer is not necessary, whereas in case of assignment, notice of assignment must be given. Negotiation is affected by delivery in case of an instrument payable to bearer and by delivery and endorsement in case of instrument payable to order. Assignment is affected only in writing. Transferee can sue the third party in his own name in case of a negotiation, whereas in case of assignee, he cannot sue a third party. In case of a negotiation, there are number of presumptions in favor of holder and due course. There is no presumption in case of assignment. Dishonor of check, you can expect a question. What are on different cases of dishonor? What are the suitable remedies? You can go through the examples. It will give you an idea. You should have a fair idea regarding noting and protest. What is a noting? Once an instrument is dishonored for any reason, the holder may cause the dishonor to be noted by a notary public upon instrument or upon a paper attached thereto and a party up to. The noting must be made with a reasonable time after due course. The noting must specify the date of dishonor, the reason is assigned for such dishonor, and or if the instrument has not been expressly dishonored, the reason that the holder treats it as dishonored and notary charges. So as to make it simple, noting is the process where a notary note the dishonor. What is protest? A certificate of noting is called protest. So that's it for this chapter. Most important topics we have covered. You should be having fair idea on the different examples given. This chapter is more of a scenario based question you can expect more of rather than from a direct question. Thank you for watching.